This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why litigation sloth will always defeat a suit against an insurer, or anyone else for that matter, and taking 6 years to sue insurers was time-barred. The appellate courts of the state of New York are noted for their ability to resolve an appeal quickly and with brevity. The Supreme Court, in New York the trial court, dismissed the plaintiff's complaint against Allied World National Insurance Company as time-barred because plaintiffs commenced their action 8 years after Allied's disclaimer of insurance coverage. In Kent Avenue Property 3 LLC versus Allied World National Insurance Company and Scottsdale Insurance Company, a New York Supreme Court First Department Court of Appeal on June 6, 2024, resolved the dispute quickly and with great brevity. The Supreme Court for Bronx County on June 6, 2024, resolved the dispute filed by the plaintiffs against their insurers. Fidel E. Gomez, judge of Bronx County, entered on May 30, 2023, a denial of plaintiff's cross-motion for summary judgment declaring that defendant Allied World National Insurance Company is obligated to defend and indemnify the plaintiffs. The court granted Allied's motion to dismiss the complaint as against it and dismissed the complaint in its entirety because in September of 2013, plaintiffs possessed sufficient information to formulate the factual basis for the assertion that the disclaimer was untimely under insurance law, and thus the statute of limitations began to run. Accordingly, the appellate court found that plaintiff's action commenced on October 29, 2021, and it was found to be time-barred under the 6-year statute of limitations in state of New York statutes. The appellate court concluded that the Supreme Court, the trial court, properly searched the record and dismissed the complaint against the remaining defendant, Scottsdale Insurance Company, as well, since the claims were similarly time-barred. In view of the foregoing, the court properly denied plaintiff's cross-motion for summary judgment as moot. In my opinion, statutes of limitation exist to protect litigants against stale claims. The state of New York's limitation period is 6 years. That's plenty of time to get around to filing a lawsuit. The decision of the trial court and the appellate court were obvious. The appeal was unworthy and proved that you just can't sue an insurance company and always get rich, especially when you wait 8 years after the claim is rejected to file suit. This video was adapted from my blog Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you do, you will receive notice of every blog posting, usually 5, sometimes 6 a week. And they will be cases that may or may not be important but are of interest to me. Please tell your friends and colleagues about this blog and the videos, and let them also subscribe to the blog and the videos. They're free. And if you're interested in more detail about insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, $5 a month or $50 a year, subscribe to my Substack publication. Thank you for your attention.